what they're saying here is if Trump wants to make an advice of counsel defense, which he said that he does, he's going to have to put some of that information into the public. And they'd like to see it now, essentially. So they're essentially trying to speed up the schedule and kind of trying to get that on the table before the trial begins. There's some extended explanation of why they think that's appropriate. But I did read this as kind of a signal to Trump that, he can't keep saying one thing and doing another. If he's going to talk about advice of counsel defense, he needs to actually hand over that information.
I'm Benjamin Wittes, and this is the Lawfare Podcast, October 14th, 2023. It's another episode of Trump Trials and Tribulations, our YouTube live stream conducted live on Zoom for Lawfare Materials supporters. This week, we heard from Roger Parloff straight out of the hearing before Judge Eileen Cannon on whether witnesses in the Mar-a-Lago case had conflicts of interest. We also heard from Anna Bauer, who was straight off of 2 days of hearings in the Fulton County case, and Quinta Jurecic gave us an update from Judge Tanya Chutkan's courtroom on all the motions that have been filed since the last time. We also took audience questions, which you can submit in the future if you become a material supporter of Lawfare. It's the Lawfare Podcast, Trump Trials and Tribulations, hearing updates from Mar-a-Lago and Fulton County. Let's start, Roger, with South Florida. What were you in court today to listen to hearings on?
Yes, and just to, I'm in Fort Pierce. You misspoke.
Sorry.
Yeah, there were 2 hearings. They're called Garcia hearings in the circuit, the 11th Circuit, and probably the 5th Circuit too. And these are hearings where the government asked for. He wants the judge to apprise the defendants. In fact, both of the Trump's co-defendants, about potential conflicts or actual conflicts that their lawyers may have, and to waive those knowingly or intelligently. Or to be, the government originally wanted the judge to actually supply independent counsel to be there to explain these things to them privately, but the judge declined to do that. Government also originally wanted, part of the problem is both attorneys have represented people that are now government witnesses or likely to be government witnesses.
So wait, let me just pause you on that, because that's an unusual situation. These are 2 lawyers who have defendants in the case. One is Walt Nada, and he's represented by Stanley Woodward, I believe.
Yes.
And the other is Mr. De Oliveira, who was indicted later than the first 2. And he is represented by Mr. Irving. And both of these lawyers have other clients who are likely to or may be called as witnesses. Is that?
That's right.
So as a preliminary matter, I just want to ask, why is that even remotely okay? Isn't there some rule that says, if I'm representing Anna and Quinta's going to testify against Anna, I can't also be representing Quinta?
Well, so the background, there are 2 rights that you have. You have a right to be represented by conflict-free counsel, but you also have a right to be represented by counsel of your choice. And so to a degree, you can waive some conflicts. And then there's a fuzzy line. At some point, you reach the fuzzy line, and beyond that, you can no longer even waive the conflict, but it's blurry. here, for instance, with John Irving, the fourth, representing de Oliveira, I think most of us can understand why the conflicts were clearly waivable. To begin with, as soon as the government brought them up, he stopped representing the other witnesses in question. So this lawyer, Irving, no longer represents the people that the government may call. And he has another co-counsel who will do the cross-examination of those witnesses. The issue that arises, even if you formerly represented somebody, is that while you represented them, you had a confidential relationship. They told you stuff, and you should not be using that when you cross-examine them. But if you have a co-counsel who was never in on any of that, and you've kept a wall, and you aren't telling him, ask him this, then it may be okay. And ideally, the witness also waives, maybe the witness himself will say, okay, I don't mind the fact that he used to represent me. It's not a problem. And that's what happened in the case of de Oliveira and John Irving.
Okay, so they do these kind of separately, right?
Yes, there were two separate hearings.
And for those who've never been to a hearing like this, think of it as kind of like an arraignment or almost a plea hearing. You're having, the judge is having, and the lawyers are having a conversation with the defendant to make sure that he is aware of all the factors and has knowingly given up, knowingly waived. It's basically a colloquy, right?
Exactly. It's a lot like a guilty plea. You go through and you understand this, right? Yeah, I understand. And you understand you're waiving that, right? Yeah, I understand. And so she went through that. And, usually there's sort of a script that's available, if this has happened before, and there's a way to cover all the points. And she did that competently. And de Oliveira came to this country from Portugal when he was 17. He never completed high school. So you're sort of asking him fairly sophisticated questions about, you understand on cross-examination, he won't be able to use the stuff that, and at the end and he goes, yes. And at the end, she said, can you explain in your own words the conflict we're talking about? And of course, he couldn't really, but they go through anyway, and he waved, and I think it'll hold up. The problem was with Nauta, all of the conflicts are more serious. And on top of that, the government raised some new issues today that weren't in the briefing, and the judge was upset about that.
All right, so let's dispense with Irving and de Oliveira, because that sounds like the simple one. They go through the colloquy. What happens? Why is it not simply routine? You say they got through it and you think it'll hold up, but the government also raised some issues in that briefing, in that colloquy, that then had implications for Mr. Nauta and his lawyer, Stanley Woodward. What did the government bring up, and why did it irritate Judge Cannon?
Yeah, and it not only irritated, but it blew up the hearing. She couldn't complete the hearing. She needed to stop it and have more briefing, and of course that irritated her. And in the papers, they talked about the obvious conflict of the one I just mentioned, where you have client confidences with the witness, and the danger is that you can't use those. You need to protect that witness. And if you're cross-examining the witness, you sort of have to hold back, because you may know stuff from those confidences that you could really zing him with, but you can't do that. So you can't be as zealous as you might be. Today, they mentioned something else. They said that, actually, when it comes to summation, if you want to say that these witnesses that you used to represent are lying, you want to question their credibility. Beyond the issue of client confidences, there's an issue of client loyalty. We think there's some case law, and they cited 3 district court rulings from New York. And there's some case law that says that you really shouldn't be impugning the credibility of a former client. And as I'll mention with Woodward, it's actually a current client. Here are the differences between Nauda's situation and Oliveira's. It's a certain, to begin with, it's a certainty the government is calling this guy called Trump Employee 4. And so it's not they may call him, it's a certainty. They are called.
So just to be clear, in Woodward's case, the other client will definitely be called as a witness, where in Irving's case, it's sort of hypothetical. He represents people who could be called.
Yes. And now, Trump Employee 4, who reportedly is Yuscil Taveras, he's the IT director down there, he does have a new lawyer at this point. Still, his situation is aggravated. Nobody's accusing Woodward of wrongdoing. Nobody's accusing Woodward of wrongdoing. But while he was represented by Woodward, he gave grand jury testimony that the government says, and that he now says, was perjury. And then after he ceased to be represented by Woodward, he corrected that testimony, and it's now inculpatory of all the others. So to cross-examine him, you will be cross-examining on that change of testimony. And Woodward does have a particular information that's relevant to that. And the government says it's even possible, if not likely, that during cross or re-examination, it may emerge, that it may come out from an answer that Woodward represented that client. Another difference is that the other witness who may testify against Nauda is a current client of Woodward's. And that's different from, that's importantly different also. So you had, then a third difference is that certainly Trump Employee 4 has not waived the client confidences that Woodward possesses.
So I'm hung up here. So in the Irving hearing, which comes first, I take it, the government says, oh, by the way, there's this other issue that we didn't mention in any of the briefing, which is what are they going to do in summation? Are they going to smear their former clients? And Oliveira says, well, if that happens, I waive. It's not a problem for me.
Well, it's a little better than that. I mean, he did waive. And but Irving said, you know what? These things, these allegations he makes, some of them, we're not going to say that he's lying. We're going to say you're misunderstanding what he was saying. And, so we don't need to go there.
So, okay. So you can paper it over in the Irving de Oliveira case, but then now it's time to deal with Woodward and Nauda, where the conflicts are much more severe, and you would have to, and you can't necessarily say this about your own client, your current client, in summation. You really have to say, oh, if Quinta Jurecic testified that about Anna Bauer, but Quinta Jurecic is a known notorious liar, and and here's all the dirt I have. How does that not immediately become an unbridgeable conflict?
Well, it's interesting because Woodward takes the position that these cases are not good law and there's no 11th Circuit law on point.
So he's allowed to slime his own client?
That's how I understood it. That's how I understood.
Remind me to hire a different lawyer.
And Judge Cannon seemed skeptical of these cases as well, but she was mainly pissed that they weren't brought up earlier so that everyone could be prepared to address them. And certainly Woodward had not prepped his client. He had not said, to waive these potentially, he'd not said, it may come up that on cross-examination, that on summation, I'll be precluded from attacking the credibility of these opposing witnesses, because he didn't think that's the law. He doesn't think that's the law. So that's when it fell apart. And the judge said we need more briefing and we needed to schedule a new follow-up.
All right. So is that how she left it? What, as in,
yeah,
we need to brief these cases and I'll reschedule a different hearing?
Another one for him. The one again for the Oliveira was completed. He waived.
Right.
That's over.
All right. So before we move on to Fulton County, I would be remiss if I didn't ask you for an Eileen Cannon behavior check. She's the big mystery figure in all of this. The last time we checked in about her, you were bewildered by her attitudes towards SEPA and her propensity to slowness. How did she do today?
She was pretty good. I hadn't seen her before. Anna has seen her before. But
you've read her
yes,
orders.
Yes, I've
and
read
been
her.
Bewildered by them.
Yeah, this is the first time I saw her, and like to do the guilty plea portion, is
pretty
sort
routine.
Of right, and she did it competently, and she was. But when this issue first arose, at first I was a little startled. She was with the Oliveira, she was already angered that this came up, and I was a little startled because I just thought, well, he's waiving everything. Why don't you just ask him, will you waive this? And of course he did waive it, but she was already angry. I don't know if she foresaw that what a big change this was going to make with Nauta. Now, because there wasn't a comparable screw up, and this was sort of a screw up. I mean, there isn't really, they didn't have a good answer. It was like, well, in the other brief, this was enough to ask for the hearing, so we didn't put this in. But, that's not good. Everyone needs to be prepared, and she's may need to make a ruling about what's waivable and what isn't. So it was the government here that screwed up, and so she was pissed at the government. So it wasn't a very good test case because the other side didn't screw up.
But she didn't do anything from your point of view that was out of the normal range for a federal judge.
No, she did begin to use some. She at one point she said, "So the new flavor you're spinning now is such an." She was very sarcastic and skeptical, and it seemed, there were aspects of it that suddenly this person that seemed reasonable, and suddenly there was this anger, but again, some of it was justified.
Mm-hmm. All right, let's go to skip a day, which is yesterday, and go back to Tuesday, when the first of the Fulton County hearings happened this week. Anna, tell us about the issue that was before the court on Tuesday.
Yeah, so we had a few issues before the court in Fulton County on Tuesday. And just to kind of tell everyone where we're at right now, this is the pretrial motion phase of the Kenneth Chesbrough and Sidney Powell case, which is set to start jury selection on October 20th. So I think that's 8 days from now, which is really crazy. But so Judge McAfee set a number of hearings on a lot of these pretrial motions to dismiss or general demurrers. I think that's how you say it. It's a special term for a type of motion that they use in Georgia to challenge the indictment and get charges dismissed. So
so I'm going to pause you right there, because we had a big conversation in the lawfare office among several lawyers and fake lawyers who do not practice or not fake practice in Georgia, all about the question of what a demurrer is and whether it is or is not the same thing as a motion to dismiss. And we were all quite hamstrung in this conversation by not being Georgia lawyers or fake lawyers. There seem to be both motions to dismiss and general demurrers filed in this case. For the total Georgia criminal practice nerds, what's the difference?
Yeah, so a general demur is more about how the indictment was written and whether, they've handed down, a valid indictment that has all of the elements that one would need to have in order to kind of claim that someone's violated the statute, right? So it's more about kind of, is the indictment and the way it's written sufficient? Whereas you have motions to dismiss that are less about the way that the indictment has been written and more about, you might have immunity claims, you might have other kind of legal challenges to the crime as charged that doesn't really have to do with exactly how you've written the indictment. Does that make sense?
It makes enough sense for now. I could ask you 100 questions about whether this argument would be a general demur or a motion to dismiss, and this one, where the line is between the two. But that would take us down a crazy rabbit hole that would have the audience rolling their eyes. So let's go on to, these were general demurs, not motions to dismiss. And for purposes of the rest of the conversation, right, that's a distinction without a difference. They would both result in the charges getting thrown out.
Yeah, I mean, and some of them that we were talking about at these hearings were motions to dismiss. Some of them were general demurs, but I do think that for the purposes of this conversation, it's just easier to refer to them as motions to dismiss the charges or motions to quash the indictment.
Throw out the indictment. All exactly. Right, so how many of them were argued on Tuesday?
So the first day on Tuesday, on the 10th, we had 3 motions that were argued, and some of them were just Chesbrough, some of them were Chesbrough and Powell. But just to give you a rundown of those motions, the first one was a motion to dismiss based on supremacy clause grounds. And Ben, that's one of the motions that we spoke to Chesbrough's attorneys about on the Lawfare podcast.
I believe it's the one that I told them I thought was a loser. Did Judge McAfee agree with me?
That's the one. So it's hard to tell what Judge McAfee thought exactly based on the questions, but what I can say that I got a sense of from his questioning and from his comments on that one is that he thinks that this motion is something that you might raise at a directed verdict stage. So that's after the jury has heard all of the evidence and the parties have made their arguments, and then defense counsel will stand up and say, Your Honor, we move for a directed verdict. And it's at that point that the judge will have to decide whether or not, the state raised enough evidence and there's kind of this whole, calculus with that. And so the judge was saying that maybe they could raise this supremacy clause issue at the directed verdict stage, but he felt like there was too much factual development maybe that needed to happen before the issue could be raised. So he thought it was he seemed to think it was just at this procedural juncture, it was not appropriate. He made some comment about, maybe we should have a defense or a criminal defendant equivalent of a summary judgment standard that you would maybe have in a civil case, but that's not what we have. And so, maybe you bring this to my attention later on. And that's also kind of the reaction that he had to the second motion that we heard, which was a motion to dismiss based on First Amendment protections, because Powell and Chesbrough, or actually maybe it's just Chesbrough on that one, but the argument was in essence that, the conduct that has been charged in various counts related to, the fake elector scheme and Chesbrough writing the memos as the so-called architect of that scheme, that was all First Amendment protected activity. And Judge McAfee again kind of mentioned that he thought that there was just too much in the oral argument that was about factual issues and factual development. And so he seems to think that it was not at this stage something that was appropriate to raise, but he didn't rule from the bench on either of those. So we are still waiting to hear on those two. And then the final one on Tuesday was a motion to exclude legal memorandum from the trial. That was relevant to Mr. Chesbrough, particularly because, of course, the main evidence in the state's case in chief, as far as I'm aware, against Mr. Chesbrough is this series of legal memos, as he calls them, in which he sets out, various views on the Electoral Count Act and how potentially the Trump electors could meet. And then as we go into January 6th, how potentially Joe Biden could be essentially blocked from meeting the number of votes that would be needed at the joint session of Congress to become president. So that series of memos is a big part of the case against Mr. Chesbrough. So they have sought to exclude those memos based on attorney-client privilege grounds.
And there's realistically, that's functionally a motion to dismiss, right? Because the government, without those memos, the government has no case against Ken Chesbrough.
That's right. I mean, they have a few things that are like emails where Chesbrough is, emailing people like David Schaefer with instructions for how to fill out these electoral certificates. But even that, I believe, has been included in, what has been called the legal memorandum or attorney work product kind of stuff. So it is essentially does function as a motion to dismiss, as I understand it, even though it's basically a motion in limine in terms of, how it's written and what the judge has to decide, because the question is whether it can come into evidence. And on that one, I think Judge McAfee, because the prosecution has raised a number of arguments about that in response.
Wait, before you go into this, let me just give a little bit of background for people who don't know the law of attorney-client privilege. General rule, you write a memo to a client and that memo hasn't been voluntarily disclosed to anybody else, that's not coming in as evidence against the client. That's the molten core of attorney-client privilege material. Three things could override the privilege here. One is this guy actually a lawyer for the Trump campaign, or is he some rando who shows up off the street and starts writing memos, right? It has to actually be a communication with a client, and exactly what Ken Chesborough's relationship is with the Trump campaign and with Donald Trump becomes important. Second question, that's going to be that may be really important here is, has the client waived the privilege? Or, because just like you can waive your your conflicts with your lawyer, you can also waive the attorney-client privilege. And Donald Trump has said he's going to defend his federal case, or his lawyers have, by arguing that he was acting on advice of counsel, right? So in order to do that, he's going to have to establish at the federal level that there was a basis for that the lawyers were actually advising him that what he was doing is okay. One of those lawyers is Ken Chesebro, and some of the material in question is this set of memos. And so it's possible that he either has waived or means to waive the privilege, which would not be helpful to Ken Chesebro, but might be the right way for Donald Trump to try to defend himself. Third issue, there's the crime fraud exception to the privilege, and you cannot use your attorney's. The privilege falls where you are using an attorney's advice in order to commit a crime. And so my assumption here is that the government's argument, and Anna, tell me if this is not what they said, is that they think that they can establish either that Ken Chesebro was not, in fact, a retained counsel, or that Donald Trump is going to waive, or most probably, I think, that the evidence shows that Trump was using this legal advice to commit a crime. Is that where the government is? And which one of those are they arguing?
Right. It's kind of all three. There were elements of all three in the argument. One is that they argued that Chesebro had not shown any evidence that he actually was engaged by the Trump campaign to do legal work for them.
Just a crypto bro who walked in off the street.
Right. And so as a result, Judge McAfee did order the attorneys to file under seal. They in response said, we have proof of this. We have an email. He was working pro bono, so we don't have an engagement letter, but we do have, an email that we think will be sufficient to show that he was.
My pro bono lawyers, there's always an engagement letter.
Well, yeah, I don't know what the situation was with this email and with Mr. Chesebro specifically, but they say that they think they have something that Judge
query whether that's going to end up being litigated.
Right.
Because when you want to show that you're somebody's lawyer, you want to be able to produce the engagement letter.
Right. And so they are going to file something under seal that Judge McAfee will take a look at himself to decide on that point that you've raised of whether or not he really was an attorney working for the Trump campaign. On the second part of waiver, the state kind of pointed to these maybe like implied waivers of some of the memos. So, for example, sending David Schaefer, who was not a client of the Trump campaign or of Mr. Chesebro, sending someone like David Schaefer, who's not a client, a third party, instructions for how to fill out the certificates. They said that is functionally a kind of waiver of sorts. And then the last point is the one that was really focused on the most, which is the crime fraud exception. And where Judge McAfee ended on that was, he seemed to, again, focus on, they only have to raise a prima facie case of meeting the crime fraud exception. It's a preponderance of evidence standard. And even if I am not prepared now to say whether or not they've met that, why can't we just do what we usually would do in this kind of situation in Georgia, which would be to have the state proffer the evidence and then they can prove it up as we go through trial. And as we go through trial, if I decide that they haven't, proved that they've met the crime fraud exception, then we're in mistrial territory. So he kind of said that at least conditionally, maybe it could be admitted on that, kind of method. But then in the end, he ended up saying, what I want the parties to do is I want Mr. Chesbrough to submit under seal the thing that proves that he was an attorney. I also want to see under seal the things that you guys actually want excluded, that you're asking to get excluded. And then, I think that he instructed, to my memory, he instructed the prosecution as well, kind of after that process, to submit the materials that they had argued were proof of the exception being met. So things like the January 6th report, the federal indictment. They kind of raised these extra Fulton County case materials that they wanted to submit as kind of a prima facie case or proof of meeting the exception. And of course, Chesbrough's attorneys argued in response to that you can't just submit like a federal indictment and say that you've met your burden. Like they did not think that was sufficient. And so I think there's still going to be some behind the scenes, maybe argument over those things. But Judge McAfee is going to consider it and make a decision. So we don't have a ruling on that yet, but we'll see.
So that gets us through Tuesday. And then we were back in action on Wednesday. What was before the court then?
Wednesday was RICO Day in Fulton County, just like every day in Fulton County, it seems like. But we were focused on that day with pretrial motions that were challenging the RICO charges in the case, which of course are is the kind of glue of the case. It's the main charge that every single defendant in the case is charged with. And if the RICO count is gone, the state still has a lot of these leftover separate charges that are kind of discrete charges, but they're at a real disadvantage because of some of the evidentiary kind of benefits of charging someone with RICO, because you get to bring in a whole lot of evidence that you usually wouldn't if you're just prosecuting a case that has just a discrete charge that's not based on RICO. So the two main motions that we focused on, the first, again, Ben, it's a motion that we talked to Chesbrough's attorneys about. So it's this motion in which they argue that the RICO charge must be dismissed because the indictment doesn't sufficiently allege that the conspiracy to overturn the election was motivated by pecuniary gain or physical threat. And the argument here, it's a little bit of a novel one, but they're saying that under Georgia's RICO statute, there's this legislative statement of purpose or statement of intent. And it basically kind of says, we're enacting this law because we want to use it to focus on conspiracies that are motivated by pecuniary gain or physical threat or physical harm. And so they're saying basically that's an element of the crime itself. That's an element of the RICO charge.
Yeah, this didn't work for the gun control people with the Second Amendment.
Right.
Which has a statement of purpose in it, and the Supreme Court doesn't care. Does Judge McAfee appear to care about the prefatory purpose statement in the RICO statute in Georgia?
I don't think Judge McAfee seemed to care, but he's very even keeled. He did not seem to.
He really is. He really doesn't show his cards.
Yeah, he didn't show his cards a whole lot, but I have to say that. Again, I will stress that this is a pretty novel question of law. And so I would be really surprised if Judge McAfee, took it upon himself to declare that pecuniary gain and physical threat is something that is an element of the RICO statute in Georgia. So I will be very surprised if he agrees with Chesbrough's team, although I do wonder what maybe some of the appellate courts will say. It's a really interesting argument. Although on the facts here, I think that the state has made the case that there are elements of this enterprise that were motivated by pecuniary gain and physical threat. You have the harassment campaign against Ruby Freeman. You have the fact that winning the presidency means that you get all kinds of economic benefits and other types of benefits. So I think that they, even if an appellate court were to say, yeah, actually, this is right, you've got to have some kind of showing of pecuniary gain or motivated or effect of economic benefit or physical threat, I still am not sure that really serves to defeat the charges here. And then, okay, so moving on to the next big RICO motion that went down on Wednesday in Fulton County. It was, again, a motion that we discussed on the podcast, and it was this continuity question. And this one gets a little bit complicated, but the gist of it is that in federal RICO practice, you typically have one of the elements being showing that there was continuity of the criminal activity or of the so-called predicate acts.
Yeah, this is their best motion.
Yeah, and
I think this one, I don't think it has legs at the district court level, but I think it's a very interesting motion, and I think, if any of their motions to dismiss has traction, it's this one, I think.
Yeah, it's a super interesting argument. And it's one that I think, Ben, we talked about this with them, but there's a lot of more federal case law on this, but not so much Georgia case law. And, in the room was John Floyd, who is the leading expert on RICO in Georgia and one of the leading, RICO experts nationwide. And he made some pretty compelling arguments, I think, about the textual differences between the federal RICO statute and the Georgia RICO statute.
On behalf of the state.
Yeah. So yes, on behalf of the state, and making arguments about why the specific provision under Georgia's RICO statute that these folks are charged with has a different kind of a series of elements, because it's a conspiracy to violate RICO rather than just a straight, violation of the RICO statute itself. So they differentiated on those grounds. And I do think maybe the state will get the upper hand here again, in part because it's a novel territory. And I just really doubt that a trial court judge is going to take it upon himself to kind of declare new law, especially in the Georgia's trial of the century. So if this does result in any kind of, relief for the defendant, it probably
will be on direct appeal.
Yeah. Mm-hmm. And I should say they can ask for interlocutory appeal. So they could ask for it before the trial, but Judge McAfee indicated last week that that's unlikely. So I think that it will probably be on direct appeal that this may get taken up by Georgia's appellate courts.
And I assume he declared it unlikely because they're the ones who are pushing for a speedy trial, right? So you don't get to say speedy trial rights with one hand and, can we pause for 4 months so we can appeal something in the meantime?
Yeah, exactly. That's exactly what he said to Scott Grubman and Manny Aurora, Chesbro's attorneys. He was kind of like, well, you guys are the ones who have asked for the speedy trial, and we're going to try to seat a jury by November 5th, I think it is. And so that's what we're going to do. And it kind of, that seemed to be the tenor of what he was saying. So I'll be really surprised if he grants interlocutory appeal, which in Georgia is discretionary on those matters.
All right. So Quinta, long waiting, sitting there while others talk. Quinta Jurecic, you have been following Judge Tanya Chutkin this week. What has the good judge been up to, and what's been going on in her court?
So we've had less activity in the federal January 6th case than in the other two cases we've discussed. I don't have any stories of courtroom excitement and daring do, like Roger and Anna. What we have had is a series of pretty interesting motions. So last week, repeat viewers will remember we talked about a motion to dismiss that Trump had just filed on the grounds of presidential immunity, essentially arguing first that there exists immunity from criminal prosecution for presidents for conduct that's within the outer perimeter of their official duties, and second, that Trump's actions as described in the indictment leading up to January 6th were within the scope of his official duties as president. I'm not going to belabor that, although we can talk about it more because we discussed it a bit last time. I'll just say that we're still waiting for DOJ to file its response, or for the special counsel to file its response, rather. And I think we're all going to be very interested in what they say, since clearly they've thought this issue through. They brought the indictment in the first place, but responding to the sort of arguments that Trump sets out and how they choose to do that will be very telling.
Yeah. So before you go on, I will just flag again that this is whether Trump prevails on it or not. And I do not believe there are 5 votes on the Supreme Court for Trump's theory, combined legal and factual theory of the case. This issue has the potential to delay the case in a very important way, because when Tanya Chutkan rejects this motion and denies this motion, which she will, that is almost certainly subject to interlocutory appeal, which will freeze the case for some period of time while it goes up to the DC Circuit and maybe the Supreme Court. So I think we can go into why if somebody asks, but someone
really wants to know about the intricacies of civil procedure.
This is a criminal procedure. This is or it's really appellate criminal procedure. But if people want to talk about it, we can talk about it. But it's the major significance of this motion is twofold. One, that it will in some way for the first time establish the answer to the question, to what extent does the president have immunity from criminal charge? Answer will not be not at all. Probably, one hopes, will not be as broad and inclusive as Trump is arguing for. But the Supreme Court is going to have to answer this question in response to this motion. That's important fact number one. Important fact number two is that may take some time to do. And that time could be very beneficial to Donald Trump. Quinta, the floor is once again yours.
No, I think that's absolutely right. If anyone's interested in kind of a high-level overview of the issues regarding interlocutory appeals, Ruth Marcus at the Washington Post's editorial page has written about this. Trump loves to make interlocutory appeals, which is why I made my slip there. He's made a lot of them in civil cases, and so I'm sure he's excited to bring that to criminal cases as well. So moving on to the other motions that I think are of interest. So there are 2 that were filed by the special counsel's office earlier this week that are both interesting in different ways. The first is a motion that's styled as a motion for fair and protective jury procedures. And essentially what that is asking for is for the court to sort of formalize the typical system that the federal courts in DC have for jury selection. The government emphasizes repeatedly that they're not actually asking for anything out of the ordinary. They're not asking for the jurors to be sequestered or anything like that. But there are typical procedures that the courts in DC will use to make sure that jurors' identities aren't widely distributed, and they sort of want that locked in ahead of time to ensure that everyone is safe, essentially. And they say explicitly, we are asking for this in light of, and I'll quote here from the motion, in light of the public attention that is expected and the defendant's record of using public social media platforms in an intimidating manner, further evinced by events in a separate trial in New York last week. Now, what it's referring to there, as they say later on in the motion, is a post that Trump made on Truth Social about a clerk of the court in New York State Court in the civil trial regarding the alleged fraud in the Trump Organization, where Trump posted on Truth Social a picture of a female clerk saying falsely that she was Chuck Schumer's girlfriend and essentially directing harassment her way. Judge Arthur Engoron, who's the judge in that case, did not take particularly kindly to that and ruled from the bench, essentially limiting what people could say about the trial on social media. So the special counsel's office is clearly aware of that, is referencing it explicitly, and says, and I quote, there is cause for concern about what the defendant may do with social media research on potential jurors in this case. So I found this very notable. It's also notable that we don't have the Trump team's opposition, but it does say that this is an opposed motion. So, not only is the government asking for this, Trump is pushing back. And I think this is kind of an interesting opening salvo in what may be a telling negotiation, let's say, in terms of what Trump wants to be able to learn and say about potential jurors. So that's one motion. The other motion from the government, which is also opposed by Trump, is a motion to essentially, in colloquial terms, make Trump put up or shut up when it comes to the advice of counsel defense. So what I'm referring to there, for listeners who haven't tracked closely, is that Trump's lawyers have said a number of times in interviews that he plans to argue that the actions that he took for which he was indicted regarding January 6th were pursuant to the advice of counsel. So this is a legal defense that he can make if he wishes. These comments have been made in a number of media interviews, which the government cites at length. And what they're essentially saying here is, okay, you want to make that argument, you then need to hand over the material that you're going to use to make that argument. And that is relevant because, and again, I'm just going to quote from the motion here, which I have in front of me, at least 25 witnesses during the investigation withheld information, communications, and documents based on assertion of the attorney-client privilege under circumstances where the privilege holder appears to be the defendant or his 2020 presidential campaign. These included co-conspirators, so I'm assuming co-conspirators who are numbered 1 through 6 in the original indictment, former campaign employees, the campaign itself, outside attorneys, a non-attorney intermediary, and even a family member of the defendant. So we can all make our guesses about who that might be. I don't know. But this is crucial because it means that, there's a lot of people who the special counsel's office tried to talk to who they were not able to talk to because they were invoking attorney-client privilege. If what they're saying here is, if Trump wants to make an advice of counsel defense, which he said that he does, he's going to have to put some of that information into the public. And they'd like to see it now, essentially. So they're essentially trying to speed up the schedule and kind of trying to get that on the table before the trial begins. There's some extended explanation of why they think that's appropriate. But I did read this as kind of a signal to Trump that, he can't keep saying one thing and doing another. If he's going to talk about advice of counsel defense, he needs to actually hand over that information.
And so let's be clear that, first of all, this has significant implications for the motion that Anna was talking about. So notice the interactions between the two cases here. This would, I think the technical criminal procedure term is fuck Ken Chesborough's advice of counsel defense. Not advice of counsel defense, attorney-client privilege argument on the suppression motion.
And he could be one of the co-conspirators that's listed here who
he
refused to testify.
Is.
Exactly.
Right. But the second point is that I think the subtext of this motion, and here I don't know if speculating or psychoanalyzing a little bit, but the theory is that I think that the government is working with here is that Trump won't actually waive because if he waives, then all these people who privately advised him, you could go to jail for this, all of that becomes admissible. And so I think Quinta's original formulation of this as a put up or shut up motion is quite correct. And it also has a bit of a go ahead, make our day quality to it.
Right. I think that's totally fair. And I will be very interested to see how Trump's team responds. Again, I am not an expert on the specific criminal procedure issues here, but I do wonder whether one possibility might be for Trump to just say, we don't need to decide this at this stage. And that at least helps him, give him a little more time to address to figure out how he wants to handle. So we'll see. And then the last motion that's of interest is a motion from Trump's team. And this is a motion to send out a number of subpoenas to a number of entities, including the National Archives, the Clerk of the House of Representatives, the General Counsel of the Department of Homeland Security, and two U.S. representatives. And this is for information that he claims he needs for his defense that he says was supposedly lost from the January 6th committee, sort of in the period where the January 6th committee winked out of existence, that he claims would potentially be helpful for his defense because there is such overlap between the indictment and the January 6th report. I will confess I am a little puzzled at what precisely he is referring to here. I am not aware of missing material from the January 6th committee. And it's also not completely clear to me if there even could be a subpoena with his Representative Barry Loudermilk and Representative Benny Thompson, who is the chair of the January 6th committee, given the speech or debate clause. I'm sure his lawyers know that, which makes me wonder to what extent this is just sort of bloviating posturing to make the client happy, and to what extent there actually is something going on here. I haven't seen a huge amount of reporting on this, and I'll confess I didn't have time to dig into it in any depth myself. So I'll just kind of put a big question mark over this one, unless anyone has any thoughts about what he might be referring to here.
No idea what he's referring to, but the answer to the speech or debate clause is very clear, which is that no federal court can drag a member of Congress into federal court to answer questions about legislative acts, which are construed rather broadly. On the other hand, Barry Loudermilk may want to testify, right, and therefore nothing prevents them from doing it either.
I don't know what he's talking about, but I do think that there are some material, some supporting documents that were not released by the January 6th committee, because I have in the depositions for example, reporting on our Coffee County story, there are emails that are referenced that I've never seen in the publicly available documents. However, that doesn't mean that the special counsel's office doesn't have those materials and hasn't turned them over in discovery. So I'm not really sure.
Right. That's what's puzzling, is that he's not, as I read this, he's not claiming that the materials aren't public. He's saying that they're somehow hidden, including from him. And I genuinely don't know what he's referring to.
Yeah. And in that sense, I have no idea what that could be.
All right, we are going to go to audience questions. And the first question today, the most important question, Jacob, the floor is yours.
Oh, good, because I hadn't heard recently, but the most important thing I wanted to know is, are we still first to the court hearings, first in line?
So this is, the important question. Roger, this is the first federal court hearing we've been in a while. Were you first?
I was first. But it may be getting a little sillier than it even was before, because it seemed that a lot of people got in this time. About 12 got in. Her courtroom, as Anna has told you in the past, is small. It's a fourth floor courtroom with only 2 rows. And the first row is reserved mainly for, presumably, and actually most of it was empty today. Nevertheless, it would remain reserved. I think for government lawyers or for the other side's lawyers. But anyway, a lot of people that didn't get there as soon as I did got in, and but for what it's worth, we were first.
All right, and Anna, have you been first at Fulton County these last few days?
Well, I have to admit, no, I have not. But that's because, so in Fulton County, because it's live streamed, I don't worry about getting into court, especially on these pretrial motions, because
there's never a line at Fulton County, right?
Right. There's no line. So I don't have to worry about getting there to start the line because there is no line.
So Fulton County doesn't count.
It doesn't count. I mean,
everybody has access. Judge McAfee, people, has a YouTube page, and you can watch every minute of
and it's often the videos are labeled Scott McAfee's Zoom meeting, which I find very charming.
I mean, there's like no point in standing in line.
Although, Jacob, check back in when jury selection starts, because I know that because of the nature of jury selection and the rules around, recording jurors and jury identity, I am aware that a lot more reporters will be there when it starts. So I am getting a little bit nervous about being first for jury selection because I want to make sure that I get into court.
By the way, I just wanted to say the court personnel at the federal courthouse were very, very nice about this. They noticed this old man hanging out in front of the court door, and they brought out they checked to see what it was going on, why it was there, and then they brought me out a chair, and then periodically the security guy would check out and say, "You need to use the bathroom or anything?" And remarkably, I didn't, but it was very reassuring to know that maybe I could if the need arose.
Well, just big shout out to Fort Pierce marshals and staff. That would not happen at the Barrett Prettyman Courthouse, I don't think, though the marshals there are lovely people whose love of their fellow humans outGandhi's Gandhi, I'm sure. All right. Joyce asks, I'm not a lawyer, so I'm asking to be educated. I've seen some discussion on the internet that the immunity claims don't really need to be decided before a trial, but can be litigated in the normal course after the trial. Who decides, and what are the criteria for an interlocutory appeal? So, Joyce, it will shock you to know that chatter on the internet can be false. Not only do immunity claims is this wrong, but they are unique in that they must be evaluated before trial. The theory here, so the classic example of this is speech and debate clause immunity, where the Constitution says that you're not allowed to question a member of Congress about speech and debate outside of the body, right? So a court tries to put a person on trial for a speech that she made on the floor of the House. And the Supreme Court has said that challenge to that motion to dismiss has to be appealable before trial, because the speech and debate immunity is not just an immunity. It's not just an affirmative defense. It's a protection against being tried at all. And so you have to be able to argue that before the case actually happens. And the argument here will be that presidential immunity is similarly an immunity against being tried. And I think I want to give credit to Ruth Marcus, who first spotted this issue. But I was skeptical of it and spent a little time trying to debunk her analysis. I found in trying to do so that Ruth is right, and that I just have no doubt that this will be subject to interlocutory appeal, which brings me to the following part of your question, which is what's the procedure for it? And the answer is the procedure is, if they follow what the Supreme Court said in the speech and debate clause cases, it's just a direct appeal. It just takes place right away. The DC Circuit and the Supreme Court can expedite it as much as they want, of course. So you could have the DC Circuit rule on it very quickly, but the DC Circuit's been sitting on a very similar question for over a year now. So you could also have a substantial delay. And of course, at the Supreme Court, there are no rules at all. They do whatever they want. And so I think you could imagine this it really just depends on the urgency with which the DC Circuit finds it, and whether they, like Tanya Chutkin, think it's important to keep this trial on schedule for a trial in March. And, when the Supreme Court wants to think about something that quickly, ask the executed Kirin defendants, the Nazi saboteurs, how fast the Supreme Court can consider a pretrial, or in that case, mid-trial appeal. The Nixon tapes case was extremely fast. So, the Supreme Court can move very quickly when it wants to. But if people want to slow this down and make it go past the next election, this is a great vehicle through which to do it, because it's a very meaty issue. It's a very substantial issue, and it could bear a lot of legal scholarship without being inappropriate. Okay, Josh asks, he has two questions that he wants me to read. Can Eileen Cannon's eventual decision about the Garcia matters for NADA be appealed? Roger, what do you think the answer to that is? Are Garcia rulings, they're not subject to interlocutory appeal, right?
No, I don't think so. And I suppose if they were really off the wall, you could try to bring a mandamus. But, the government, of course, doesn't want delay. I mean, what we're really trying to do here is protect, in case there's a conviction, protect the conviction. And I mean, that's what the government
specifically protect it against a habeas petition for ineffective assistance of counsel on the basis that the lawyer was conflicted.
Right. And you could theoretically, you might also be able to, if you change lawyers, your appellate lawyer might even be able to make that argument too. Appeal. So you could do it, but I don't, for the government to do it. It's interesting with some of these problems with issues with Woodward. It might be interesting whether they would consider a mandamus, but if this goes in a unexpected way, I just don't know the answer.
All right. Was there anybody surprising I assume both defendants and the relevant lawyers were at the hearings, right?
Yes. Blanche was there, Todd Blanche, and it's a little awkward. Before the thing started, you see him sort of chatting amiably with Nauta, who, isn't his client. And, but, it's all sort of in the family. So I don't think there were surprises. The four prosecutors were Jay Bratt, and the lead was David Harbach, Michael Thakur, and John Pelletieri. They're names that you might not have heard.
All right. Mr. John H., the floor is yours.
Thanks, Ben. So I was just curious if you have any thoughts on the Media Coalition's request for video access, or they asked for a bunch of alternatives to the DC District Court trial, which was docketed as a miscellaneous action last Wednesday. I'll also add that this summer I took a trip to Rhode Island and I randomly went by the federal court, and a very bored operations manager gave me a tour of the whole courthouse. And he mentioned to me that apparently they are still doing both criminal and civil trials via Zoom, not for counsel to appear, but just so the public can watch, which honestly I thought was not allowed anymore with the CARES Act expiring, but they're still doing it. And they have a webpage listing all the Zoom hearings. So, anyway, I would have also thought this motion would be, it's not a motion, I'm sorry. The request would be a dead letter. And I suspect Ben thinks that, but given that it's from so many media organizations, the Associated Press, Bloomberg, the New York Times, CNN, et cetera, you have to think they think there's some value in doing it, even if it's solely performative. So what do you think?
I think the value is solely performative. And I don't think there's any likelihood that given federal court rules, there is going to be anything broadcast outside of the courthouse. I will say that I have raised a separate question, which is whether it violates the court's rules to use Microsoft Word's auto transcription, speech to text, in order to put out a real-time caption-like transcript, which I think under the specific text of the rules probably doesn't violate the rules, but I would never do it without the court's assent. And so I've been kind of working on that question and trying to get the court's guidance as to how it interprets its rules. Stay tuned on that. But I just don't think there's any prospect of this or any other federal court authorizing a video feed of federal court criminal trial proceedings. Roger, do you disagree with that?
No, I agree. And just one note, there are other federal districts that do outlaw verbatim transcripts across the board. It would also upset their relationship with the U.S. court reporters. It would be a huge tumult. But
but nothing next to putting a camera in there. All right, the last question is from Simon, who says there's been reporting that Special Counsel Jack Smith has investigated Trump's sharing classified information about U.S. nuclear submarines with an Australian billionaire. If true, I'm wondering about what the obstacles would be to winning a case charging Trump with mishandling classified information while in office. The answer to this question is that the factual premise of the question is wrong, at least as the New York Times has reported the allegation. This took place after Trump allegedly took place. If it took place, it took place after Trump left office at Mar-a-Lago. The further answer to the question is that there is no way to charge a president with mishandling classified information while in office. The classification rules are embodied in executive order. They don't apply to the president, and the president's handling of classified information is by definition legal. That really is an area where the fact that the president did it makes it legal. Yes, Roger.
Yeah, and maybe you know more about this than I do. There might be one exception to that. There are some documents that are classified under the Atomic Energy Act rather than under those
restricted data statute.
Yeah.
So there are some material.
And importantly, there's one of those in the indictment,
right,
which is important in terms of Trump saying, I declassified all of these.
I think it's an interesting point. The submarine material is not restricted data under the Atomic Energy Act. So that type of classified information, certainly not. I will say about the restricted data category, the likelihood that you're going to test the theory that it applies by statute to the president is pretty minimal, particularly when you have a, shall we say, target-rich environment with respect to much less controversial mishandlings of material after he left office. All right, we are going to leave it there. We will be back next week, and we'll see you next time. The Lawfare podcast is produced in cooperation with the Brookings Institution. Our audio engineer this episode is the intrepid Anna Hickey of Lawfare. Hey, folks, I know what you're thinking to yourselves. You're thinking, how can I become one of the cool people who gets to ask questions on the Lawfare podcast? And I'm here to give you the answer to that. I can bring you into the light. Go to Lawfare, to lawfaremedia.org/support. Become a material supporter of Lawfare, and once a week you will get invited to Lawfare Live so that you too can be one of the cool kids at the cool table asking the questions. The Lawfare podcast is edited by Jen Patja Howell, who is definitely one of the cool kids. Our music is performed by veritable cool kid Sophia Yan, and as always, thanks for listening.